to House Healthcare, still April 9th. And we have S28, and Legislative Council is going to walk us through changes that have been made.
Great. Good afternoon, Jen Carvey from the Office of Legislative Counsel. I'm going to put this up on the screen. I think it may be in the process of getting uploaded, so I'm just going to do it from my Word document in case it's still in transition somewhere. So this is a new draft of S28. I've been working with various stakeholders on a few pieces. So I think the first change, I've done markup to show the changes from the last draft. So the first changes come in what is a new section 4 on page, what to here, 9.
We don't have.
No.
Yes, but maybe in the process of getting yes, of going between the committee assistant uploading it and it actually being accessible.
Around 2.3?
Around 2.3.
Oh, I know, I got 2.2.
No.
Yeah, 2.2 was posted earlier today, but 2.3 was posted within the last 3 minutes.
Just
2.3. Page 9 said.
2.3 on page 9. This is a new section. You ready?
Yes.
So this section is amending a section of existing law that was added or amended a couple of years ago in the SHIELD law that was worked on. So the section had already existed and we made some changes in it, and this would make some additional changes in that section. So this is a section on disclosure of protected health information and when that's prohibited. It has a number of definitions that hook to definitions in, well, the ones from 45 CFR 160 are from HIPAA, the federal HIPAA law. And then legally protected healthcare activity is the definition in Title I that we've been using throughout here, which is reproductive healthcare services and gender affirming healthcare services. And then protected health, again, is the same as in HIPAA. So in general, the current law requires a covered entity or business associate, prohibits them from disclosing protected health information unless the disclosure is permitted under HIPAA. And under current law, also there was some additional language. This was what was added as subsection C in the SHIELD bill from a few years ago that has some other prohibitions. And so this would modify that language and say, notwithstanding any provision of subsection B that says covered entity and business associate cannot disclose protected health information unless it's permitted under HIPAA. Saying, notwithstanding any provision of that, in order to protect patients and providers who engage in legally protected healthcare activity and except, this is new language, except as set forth in subdivision 2 of this subsection, a covered entity or business associate shall not disclose protected health information, and this adds, that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity. And this is new language, to any government entity other than the state of Vermont or its political subdivisions or instrumentalities, if the covered entity or business associate has reason to believe that the information will be used, 1, to conduct a criminal, civil, administrative, or professional disciplinary investigation into any person for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity. 2, to impose criminal, civil, or administrative liability or professional disciplinary action on any person for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity. Or 3, to identify any person for any of the activities described in subdivision 1 or 2, the investigation or the liability or action. So that's one place it cannot be disclosed.
Yeah. Can I ask a question? Yeah. In little I, there need to be an or at the end of that?
No, because it's 1, 2, or 3.
So wouldn't it say 1 or 2?
In lists, our format is 1, 2, or 3.
Okay.
Um,
So new update.
And then in what would now be B, subdivision B, for use in a civil or criminal action, a proceeding preliminary to a civil or criminal action, or a probate, legislative, or administrative proceeding, period. And then notwithstanding, so under current law, it's unless certain things exist. This is still that unless, but because we've added the first part, we're applying all of these, putting all of these exceptions in subdivision 2. Subdivision 2 says, notwithstanding any provision of subdivision 1 to the contrary, a covered entity or business associate may disclose protected health information that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity if the disclosure meets one or more of the following conditions. 1, the disclosure, now A, the disclosure is authorized by the patient or the patient's conservator, guardian, or other authorized legal representative. What's struck here, but may come back in some form, was the disclosure is specifically required by federal law, Vermont law, or rules adopted by the Vermont Supreme Court. What is now B, the disclosure is ordered by a court of competent jurisdiction. This is existing law pursuant to federal law, Vermont law, or rules adopted by the Vermont Supreme Court. And an order compelling disclosure, it must include the court's determination. Under existing law, it says that good cause exists to require disclosure of the information. This would change that to say that the information will not be used to impose criminal, civil, or administrative liability or professional disciplinary action on any person based solely on the fact that the person sought, obtained, provided, or facilitated a legally protected healthcare activity. It becomes now C instead of 4 is really some clarifications. So under existing law, it says the disclosure is to be made to a person designated by a covered entity or business associate. This is clarifying that that person would be also a business associate designated by the covered entity or the covered entity's business associate, and will be used solely in the defense of the covered entity or their business associate against a claim that has been made or there is a reasonable belief will be made against the covered entity or their business associate in a civil or criminal action, a proceeding preliminary to a civil or criminal action, or a probate, legislative, or administrative proceeding.
I think Daisy has a question real quick.
We're referring to this a lot, so I just want to make sure that I'm interpreting correctly. Business associate and covered entity. I know there's a reference to the statute, but I can't find it. That's referencing a relationship that's spelled out in HIPAA, correct?
Yes.
And the business associate is someone who would have a business associate's agreement with a covered entity who's covered under HIPAA, meaning they meet all of the requirements of HIPAA, correct?
And meet all of the requirements of a covered entity under HIPAA, yes. Yes.
Okay.
I'm confirming with Jessica, yes.
So this is just kind of tightening up, or bringing a lot of clarity by adding covered entity and business associate language throughout.
I think it had already largely used and was focused on covered entities and business associates. There are, so a lot of what already happens, whether we put it in state law or not, is governed by HIPAA, but there are certain disclosures under HIPAA that are permissive, but states can be more protective. So where HIPAA permits disclosure, there are some instances where the state may want to prohibit disclosure. So that's really what this language is doing.
On page 12. Line 11, stop there. The
We
term.
haven't quite gotten there yet, but
Hmm?
we haven't quite gotten there yet, but
Oh, okay.
page 12.
We'll get there.
Line 11 is the disclosure is existing law and it doesn't change. The disclosure is to the Board of Medical Practices, what you're looking at, or Office of Professional Regulation as applicable in connection with a bona fide investigation of a provider. Is this what you're looking at, Representative McFawn? Or a bona fide investigation of whether an individual who is not licensed, certified, or registered to practice a healthcare profession in Vermont engaged in unauthorized practice, whether in person or through telehealth. Okay.
Okay, my question is there a difference between a bona fide investigation and just a plain investigation?
Bona fide investigation basically means it has to be real. It has to be for a legitimate reason. It's not just, so this is, an investigation in the course of their work as the Board of Medical Practice or Office of Professional Regulation. So it's not somebody who works there using their employee status as a pretext to look into somebody's medical records, for example. I'm not suggesting anybody would, but just the point of saying bona fide is not to give the cover, not to give cover to anything done by anyone disclosing information to the Board of Medical Practice or OPR for any purpose. And then 6 that becomes E is the disclosure is to the Vermont Department of Health or Vermont Department of Disabilities, Aging and Independent Living, or both, in connection with, again, a bona fide, so real investigation of a licensed healthcare facility in Vermont. And now from your work on S18, you know how the Department of Health and Dale interact in the investigation of licensed healthcare facilities. And then there's new language at the top of page 13 that says a covered entity or business associate shall not be subject to any civil, criminal, or administrative liability or professional disciplinary action for refusing to disclose protected health information that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity in accordance with subsection C. So as long as they are following Vermont law, they are not going to be held, Vermont is not going to impose any liability or disciplinary action on them for refusing to disclose that protected health information.
Yeah.
So now I gotta ask the question, what if it's a bona fide investigation?
I'm not sure I understand the question.
Is this entity protected?
So they have, if they are acting in accordance with subsection C, which prohibits disclosures under most circumstances, but allows them under others, they would have to disclose the information if it was related to a bona fide investigation conducted by one of those 2 regulatory bodies.
So if it's bona fide, they have to.
Right.
Okay.
Can you sort of sum up for us, because this is a section that, or it is new section of law that we've never actually dug into before. Can you kind of sum up for us what this is doing?
Yeah, I mean, it's kind of what I was describing to Representative Rebecca. It's looking at areas in which there may be discretion under federal law for covered entities and business associates to provide protected health information because it falls under a may disclose portion of HIPAA. And this is saying under Vermont law, you may not disclose, you shall not disclose that information. And so it is intended to give greater protection to patients and providers or people who may be seeking or obtaining or providing legally protected healthcare activity to the extent Vermont is able to provide protections.
Right. Okay.
Anything else you would add? Project. All right, now we'll get on to some stuff you will recognize. So I've renumbered the section, so I've just indicated that. That's the only changes there. Section 8 is the Board of Medical Practice and Professional Conduct. I've made the same change in both sections 8 and I believe it's 9. This is related to the adaptive questionnaire. And it sounds like I had not fully understood what OPR was suggesting in the way of what the adaptive, they had suggested a provider approved, using a provider approved adaptive questionnaire. And so in trying to flesh out what that looked like, I put in some additional language saying the licensee is deemed to have reviewed it and determined that it was able to provide the licensee with the information necessary to meet the essential standards of acceptable and prevailing practice. In further discussion with OPR, it sounds like they really wanted to make sure that the questionnaire itself was developed by or in consultation with, which is what the language says here, healthcare professionals with clinically appropriate expertise, that it was less of a specific, that sort of by using it, yes, they were assuming that the provider thought that they were delivering appropriate care, but also that the questionnaire itself wasn't just something that somebody put online, but that was developed by or with healthcare professionals who had clinically appropriate expertise. So that there was the whole of the adaptive questionnaire and sort of all of the decision trees within it would be appropriate. So I've made that change here for your consideration in both places.
I think we took testimony that questionnaire that's currently used was developed by ACOG. Or I'm pretty sure it wasn't it? But it would meet the definition
Yeah.
of healthcare professionals with clinically appropriate expertise.
That change I made in both statutes. Now we're in the one on advanced practice registered nurses, and it's just the same.
And Jen, that relates back up to the definition of licensed professional.
No, it does. I mean, I don't believe it necessarily connects to any definition because these are in the licensing statutes for these specific professions. I'm not sure there is a term of a definition of healthcare. Oh, I guess there is a
there
healthcare
is.
provider in each of these. We should make it provider. We'll make it provider. Because there is actually a definition. That's even better. Thank you. Make that in both places here, because I think they both have that definition.
Licensed healthcare professional?
A licensed healthcare provider,
It's a provider.
Okay.
at least the physician one does. Okay. And I can double check. Thank you. It's a good catch. All right, then we get to section 11, what is now 11, which is the confidentiality of the prescriber and now pharmacist information on medications for legally protected healthcare activity. This is the one we'd had some conversation with folks in the room. And so I met with them offline and came up with this language. So first we have in subsection A, we just had one or a couple of definitions. I've added another one for non-controlled medication, which is a medication that is not a controlled substance as defined in federal law under the Federal Controlled Substances Act. Recognizing that we have significantly less control over what, or less flexibility over what goes on the label that goes on that medication. So what is now B1, upon the request of a prescribing practitioner and to the extent not expressly required under federal law, a pharmacist or other, and OPR asked that this be other licensed member of the pharmacy staff shall, and then instead of not list, it would say redact or otherwise remove the practitioner's name, this would add or initials, which seems to be more common for pharmacists, which you'll see later, but it seemed important to be consistent. So practitioner's name or initials from a fulfilled prescription for a non-controlled medication for gender-affirming healthcare services or reproductive healthcare services, and from any accompanying printed materials. There was some concern about whether the paperwork that's often stapled to the front of your bag from the pharmacy is actually part of the fulfilled prescription, or it's the accompanying. So we trying to cover all bases here. We have and any accompanying printed materials, and then strike out the reference to the name of the facility or other setting where the practitioner is prescribing. So again, the result of this would be if the practitioner requests, and it's not specifically required under federal law, someone at the pharmacy will redact or otherwise remove the practitioner's name or initials from the prescription for a non-controlled medication that's not a controlled substance, for these two types of services and from any accompanying printed materials. We have similar language in number 2, Says the pharmacist may, or upon the pharmacist's request, another member of the licensed member of the pharmacy staff shall, again, redact or otherwise remove the pharmacist's name or initials from a fulfilled prescription for a non-controlled medication for gender-affirming healthcare services or reproductive healthcare services, and from any accompanying printed materials. And third, if a prescribing practitioner dispenses medication directly to patients for gender-affirming healthcare services or reproductive healthcare services or both, the practitioner may redact or otherwise remove the practitioner's own name or initials from a fulfilled prescription for a non-controlled medication for gender-affirming healthcare services or reproductive healthcare services, and from any accompanying printed materials. Then we've expanded. Do you want me to pause?
Yeah, that removal, the redacting of the name, it's the pharmacist can remove it, but it also says other, some kind of staff.
Other licensed
Pharmacy
pharmacy staff, yep. And that is, there's licensed pharmacy technicians and licensed pharmacy interns. Actually, I think they're both registered, but it falls under, I learned, falls under the umbrella of licensure by OPR. So these are all regulated individuals. OPR regulated individuals.
Okay.
So this is not, if you have, there's just a cashier working there.
They're licensed by OPR.
Licensed by OPR, and that's why OPR wanted that licensed modifier in there. All right, then we have some changes to subsection C that says nothing in this chapter or the rules governing the pharmacy profession shall be construed to require a pharmacist or other, and then this says licensed member of a pharmacy staff to list the prescribing practitioners, we've added or pharmacist's name or initials on a fulfilled prescription for non-controlled medication for gender-affirming healthcare services or reproductive healthcare services. And then a new subsection D that says a pharmacist or other licensed member of a pharmacy staff shall be immune from civil, administrative, and criminal liability for failing to redact or remove the name of a prescriber or pharmacist when requested to do so pursuant to subdivision B1 or 2, provided, however, that this immunity shall not apply to gross negligence, recklessness, or intentional misconduct by a pharmacist or other licensed member of the pharmacy staff. This is to address concerns from the pharmacists and pharmacy staff that with the different types of software that are out there, it's possible they could inadvertently miss a request. And they were concerned about liability, but it's only for simple negligence. It does not apply to gross negligence, recklessness, or intentional misconduct.
Leslie, and then Brian.
Just curious, so those terms are defined, gross negligence, recklessness, and intentional misconduct, that's defined elsewhere?
They're legal standards.
Yeah.
Yes.
Brian. Do you think her question was going to be shorter than that? Is it?
I bit off more than I could chew.
Do you want Mario to go next?
No, I'm ready.
Swallow?
I'm
Okay.
ready. It's more, I was trying to pull it up on my computer, so I didn't have to put my glasses on. The ending of the bill with there it is. What would be an example of gross negligence, recklessness, or intentional misconduct in this case?
So I would say intentional misconduct would be throwing away the request or ignoring the request and not redacting it. Gross negligence might be not checking, knowing there could be additional information, but not checking.
I feel like this is a lawyer question versus like a pharmacist might be able to answer it, but I feel like this is a lawyer question. Like, what would be the burden of proof in court of someone making an accusation? Like, how do you prove, like, if you get it back and the provider's name's on it, how do you prove that there was gross negligence or recklessness or intentional misconduct?
There's elements to each of these are torts, so they're,
Yeah.
or it is a tort, so there'd be elements to proving it. I'm not
Okay.
gonna be able to,
So a person would need though to somehow acquire evidence to make that
oh,
argument.
yeah,
Yeah. I guess intentional misconduct could be somebody saying, my religious beliefs are that what you're doing is wrong and I refuse to take the name off. But then if you don't have it in writing, so I don't know. But I'm not saying we shouldn't do it. I'm just wondering like what power does this have? So.
Mari?
I had the same concern that, this, I understand the intent, but I'm also concerned that it, potential for abuse of this language is real, in that situation that Brian mentioned. And we have an editing question back on page 23, line 20. The pharmacist may, blah, blah, blah. Licensed member of the pharmacy staff shall. And I can't wrap my head around the may and shall, how they.
oh, so a pharmacist may redact or otherwise remove the pharmacist's name. Or upon the pharmacist's request, another licensed member of the pharmacy staff shall redact so if the pharmacist is doing it, we're not gonna tell them they
have to
do it upon their own request. So they may choose to do it. Or upon the pharmacist's request, if the pharmacist says, please take my name off or don't put my name on. Yeah,
May I ask,
Yeah, of course.
does that mean a pharmacist may choose not to do it because it says may there?
yeah, pharmacists can choose not, this is about taking their own name off.
Okay.
Sure, they could choose to leave their own
Their
name
own
on
name
it
on
as
it.
well.
Got it, sorry.
This addresses the concern that the pharmacists had that, well, what about us? We may want to.
Okay, got it. Thank you.
And so this is the language that was agreed upon with all the stakeholders. Okay.
Yes, at least all of those who were
And legislative
involved.
council.
What was involved?
The Medical Society, the Office of Professional Regulation, the Pharmacists Association. Was Vaz on? Yes, Vaz was on the call, I think. Yeah, Board of Pharmacy, that was part of OPIR, but importantly, specifically then Planned Parenthood. I can't remember if Vaz was or not.
Planned Parenthood was.
Yes, Planned Parenthood was.
But anyone who may, well, not anyone, you prescribe, fulfill, or hand out also in the case of a provider who actually stocks it by
Right, so
themselves.
that was really number 3 is
Yeah.
specifically from, that was part of the perspective brought by Planned Parenthood is that their prescribing practitioners can dispense medication directly.
Did I see a question?
Yeah.
I can
No, go ahead.
I'm just thinking about this in practice. Two things. One, I haven't even thought through, like, for the patient or end user, how this really impacts them. Like, is there any impact if they get the medication and it does have somebody's name on it? I mean, is there any?
No, because it's up to there's no burden on the patient to do anything differently here. This is really all between the prescriber and the
On them, okay.
pharmacist, right? So if the patient has a bottle with or a container with a prescriber or pharmacist's name on it, that they either won't notice or will, assume that was what was intended.
And they're not liable for anything if somebody accidentally left someone's name on it or anything like that.
Not for the patient, and that's where the accidentally left somebody's name on it piece is the.
Okay, that covers them too. The other thing is just, and so back to the in practice, if I'm a prescriber and I'm phoning in a prescription, what is the mechanism by which I would say, remove my name from this? And how can we be sure that that message or request is followed? Is it in the EHR request or however we get it, or, I mean, I message my pharmacy all the time about, specific prescriptions or aligning them, and sure enough, they still fill that prescription. So I mean, accidents happen, and I'm just curious how maybe some of our practitioners at the table, like, do you know how that would actually in practice pan out so that that
No,
request isn't lost?
Well, so some people do fax, some people still fax, and phone. So there would have to be a message on the fax transmittal sheet, or a verbal voicemail left. And then I'm familiar with Epic.
Yeah.
And I think I don't think it would be hard to add, like a checkbox that would activate a statement on the prescription transmittal to the pharmacy, please.
I think most, well, maybe we shouldn't be testifying, but I believe that the majority of prescriptions nowadays are e-prescribed.
Majority
And
of
they're-
that, some of
No.
mine are still
Yeah.
fax.
A lot of them are phone calls,
Yeah,
which the prescriber leaves there. And they would say on the message, because nobody picks up anymore, but they would say, please redact my name from the prescription. But when you e-prescribe, you can edit, because remember, a prescriber gives instructions on how to take that medication. And that's what the pharmacist gets, is they get the medication and they also get the doctor's instruction. Or I'm sorry, I shouldn't have said doctor, prescribers,
Those are
instruction.
all standardized though, for like, there's a drop down list of albuterol, and you can choose between how many times a day and if it's PRN. So they
Okay,
have to be a-
There's also other.
Yeah.
And then you can.
Before we go too far away, so there, yes, Alyssa, I think that's one of the ways I was gonna say, okay, maybe that's an avenue to it. But when this lands in the pharmacy's lap and they see the prescribing directions that are gonna be on the printout attached to the bag, and it's gonna say, remove my name. A pharmacist can get it, and unless they're trained very, very recently, they're gonna go, redact your name, yeah, right, we don't do that here. So how can we make sure that pharmacists are aware that this is a new law?
Well, the Pharmacy Association's representative is in the room, and the Board of Pharmacy was involved in creating language. I mean, I think it's going to be a matter of getting the word out, and I think to a large extent, there's going to be certain types of, or certain specific medications that, they will learn to be on the lookout for, whether there's anything on the prescription. I would think if there's certain types of medications, they might think, oh, right, this is one of the ones sometimes people ask to have their name taken off of.
Okay, thanks, that's helpful, and I'll connect with them before recording the bill.
I hate to even ask this, but do we want to ask representatives from the prescriber and pharmacy community to report back to us? Like numbers and how it's going? Numbers of instances of redaction?
No, I do not want to ask that. I don't want to collect any data about this. Personally, that's my opinion.
Because then someone's keeping the records.
Woody, is that, or are you just holding your hand? I wasn't sure if.
Stretching,
No, I have my.
I'm muttering again.
Page 8. And I'm gonna,
I was just about to go back to page 8, so I'm glad you went back to page 8.
Can we
Yes.
finish the,
well,
well, we're almost there. I just wanted to show you the effective date. So we looked at delaying the effective date on the confidentiality piece and taking the name off. And there was large reaction. So the bill will go back to being, or the act will be back to taking effect on passage. That's all. It's the last thing.
I like to gasp.
Any other questions on these changes that have been made? And then we'll go back to page 8.
I just have a question.
Okay.
Because I'm not a lawyer. What does gross negligence mean?
I'll take this down, and I don't know if you have a quick, Jess has a quick and easy. It's been a while since I took torts.
Is this defined someplace?
Not specific, I mean, it's gonna depend on, I think, on sort of what the theory of a case is. Do you have anything helpful to add here? Can I?
Just about
Concern
internal
on-
medical study, I mean, the typical definition of negligence is there was a sort of a risk and you maybe ignored the risk.
Fail to use
Failed-
reasonable care,
Right, you didn't act like a reasonable person. would
reasonably
have.
prudent person under the circumstances.
And gross
does come back
negligence
to
is a
you.
little bit higher, you know, you sort of maybe it was repeated.
Real quickly.
Well, it's correct. It's a question.
Well, let's look at
You should have
Asking
responded to
Topper's
it.
question.
I found a definition. Because it's sort of like in between gross, there's falling short of intentional misconduct, but exceeding simple negligence.
Right, so that's where we drew the line between simple negligence and gross negligence.
misconduct. So it's sort of. in
Well,
between
and
that.
gross negligence, no, we drew the line between simple negligence and gross negligence is where immunity stops.
Yeah. So is it important for us to define?
It is not, no, you have it throughout the statutes. We just don't deal with this a lot in here, because it's usually in the judiciary committees. But, let's see if I can give you a,
I see you, Alan. Hold on. Brian has a question.
Follow up on this.
Yeah, mine is too.
Okay. I just want to make sure Topper's got his questions asked.
if I can find something.
But Jen's,
I mean, it is, yeah, the term gross negligence is used 52 times in our statutes. I don't know if I can. And I may need to bring you one of my colleagues to talk to you more about it, because it's just not work I do much. I mean, I don't know what to say other than they're legal standards, and they get argued in court about whether they have been met or not.
Okay, here's what I'd like to do. Because it's mentioned a couple of times in here. Let's find out whether we need to define it.
I don't think it is definable.
So,
I mean,
okay,
I don't think it's defined in our stat, like, I think it just really depends on the circumstances. I will try to get you a clearer definition, because it has been a minute since I have had to.
It sounds like it's kind of at the next,
Oh.
there you go.
Boom.
So I'm not gonna be able to find it. for you
all
all.
right, that's, I was just saying,
okay. Hold on. I have a lot of questions and I don't want to skip over people.
It's just, it's about topics.
So is mine though.
So is everybody else's. So Brian,
Yeah, so an example, this is like, might this be an example of gross negligence? That, because I'm reading like about it. So a pharmacy gets a threat that if you dispense this medication, we're gonna go after you and the prescribing providers. And someone at the pharmacy says, I know there's this risk, but I'm still gonna put the name on it and send it out there or whatever. It says here, the elements of gross negligence is to be found in a court. Now, I'm not a lawyer. I'm just saying, like, might this be an example, though? You have to meet these things. There's a duty of care. So there's a breach of the duty. It led to an injury or damage.
Yes,
And so, like, in that case, it could be gross negligence that they simply did that. It would be gross negligence if something actually happened because they did that. And is this why it's complicated? Because a judge has to actually look at all these parts to rule it. We can't define it.
or elements.
I guess that's my question, maybe judiciary should weigh in on it too, if we're worried.
I believe that we should probably listen to our legislative council. And if we need to, perhaps if another legislative council, we could have in tomorrow to maybe give us who deals with this and works in this and because that's their area of specialty, then we could have, maybe get somebody in tomorrow. Alan, is your question an example?
I'll give you a
or-
little, like, here's a fairly recent Vermont Superior Court case. Quoting from a Vermont Supreme Court case, gross negligence is negligence that is more than an error of judgment. It is the failure to exercise even a slight degree of care owed to another. In other words, to establish gross negligence, a plaintiff must show a defendant heedlessly and palpably violated a legal duty owed to plaintiff.
Mhm.
Okay, I'll ask it if I can.
Yes.
Okay, just help me out on this. So if a person calls.
I'm not going to be able to tell you if a particular fact pattern is or any level
If a
of,
person calls to a prescriber or gets his questionnaire, everything's all set, so go to the pharmacy. And all of a sudden, is there an age limit to who can pick up a prescription?
No. Unless there's an,
Doesn't address, doesn't deal with
that
that.
doesn't have anything, there are things in existing statute around what providers can,
Who can pick it up? Nothing?
This bill doesn't mention anything to do with that.
What if it's the abortion pill?
This bill doesn't mention anything to do with ages or who picks
No,
up.
I know it don't,
prescription.
I know it doesn't, but I just, if a pharmacy does give it to a wrong person, they're not liable for
This,
that.
that's
Oh.
a different statute. We don't even.
No, that's not in
It's
here.
not in here.
It's not in this whole bill.
That's an
Yeah.
error. That's a medic, that would be a huge error.
right.
This
That-
bill is about the providers.
Okay,
So. would
It's
it be-
not about pharmacy operations.
yeah, Mari?
Just a quick, I have done legal nurse consulting before when was gross negligence. I'm not an attorney, but my memory in working with an attorney on these cases, in medicine, I think gross negligence is also dependent on what the prevailing standards are at the time and what any reasonable professional or provider in the same field would, with the current standards of practice or standards of practice that were in effect at that time about that issue, whether it was vascular access or some other field. So it's a huge broad term that gets addressed in the court by the attorneys for that specific case. And there are many details that we're just going to go into a rabbit hole about if we try to figure out medical malpractice and gross negligence in this committee.
And it's a legal term that courts define all the time based upon the situation. Is that what I'm hearing from legislative counsel?
I mean, yeah, I mean, it's,
They know what this term means.
yeah, yes, and more importantly, they are applying it. But there are, yes, for each of these, there are elements. So, from a Vermont Supreme Court case, reckless conduct requires a conscious disregard to a substantial and unjustifiable risk. Some of this is from penal code. It's, yes, it's all, it all exists in, case law, I guess is the best way I'd say it. We don't typically try to define it in statute. We refer to this sort of standard legal levels of culpability and intent. And then they get interpreted in court.
Okay. Are we done with, I really don't want to like add situations or things like that. Do we have a question about gross
Yeah,
negligence?
Yeah.
But a question.
it was a question, although now
Recklessness or intentional misconduct.
I feel like I lost it.
Well, I know,
It'll
but
come
I
back
feel
in a
like we
second.
keep going down rabbit holes.
Yeah, it
where
wasn't a
the
rabbit
people
hole
around
question.
this table are trying to,
It wasn't a rabbit hole, it was a question that might help some people let it go.
Just let it go.
well, no.
Well, but it's not gonna help me let it go, but can I just ask it? It's
Yes,
simple.
you may ask the question. Of course you may.
If the committee chose to try to define gross negligence, would that conflict with existing practice and policy of the balance of powers between the courts and the legislature? Because I heard you say the courts rule on what it means. So if we tried to define it, would that create a problem? I don't want to define it.
Create confusion.
Thank you.
You are allowed.
Healthcare redefining
The
that.
courts, the purpose of the judiciary is to interpret the law. They say what the law means.
So we create confusion if we suddenly inserted ourselves into that.
It could.
Okay.
I would recommend
And I would-
against trying to put a definition of it into the statute.
Okay,
You just said you would recommend not doing it. That's what I was getting at. Okay, thank you.
okay. Any other questions on the changes that Jen has made? Leslie?
I'm sorry I wasn't here, but I'm just curious to know what instrumentality is.
Oh, an instrumentality is something that is part of the state, but is not not the state, not at the state level and not a political subdivision. So as I believe the University of Vermont is an instrumentality of the state.
Is AHS an instrumentality?
No, it is the
It
state.
is the state. Okay, so I'm just trying to be able to see if I could figure it out. Okay, but university, anything that's in Vermont really that operates as a something in Vermont
That the state has control over,
that the state had, but
I guess, as that the state is, or a state is responsible for. Yeah, I don't have another good example off the top of my head, but
thank you.
yes, but I believe
I'll
that,
let that one go.
okay.
Okay, on changes, right?
On the what?
Changes that have been
Yeah.
made. Okay.
In the gender affirming healthcare services and the what's the other one?
Reproductive healthcare services?
The reproductive healthcare services. Are there any that you know of, or that anybody knows of, are there any non-controlled medications for either one of those?
There is only one controlled substance that I am aware of for either of those. So most are non-controlled substances. Testosterone is a controlled substance that is used in gender affirming care. Everything else is, that I'm aware of, is a non-controlled substance.
Okay, so for the controlled substance, none of this is effective, correct?
Federal law appears to require the prescriber's name on the label. There's some inconsistent language used in the federal law that I won't go into, but the general presumption is that the practitioner's name is required on the label for medication for a controlled substance.
Woody, would you like to go and ask your question?
Sure, if everyone's done.
I think everyone's done.
You done, Brian?
You're so
I'm very
good.
done. I'm finished. That's the polite way to say it.
Page 8, line 3, I think it was.
What do you,
Page 8, line 3, we are all familiar with this item. It's a word.
Oh, the behavioral one?
Yeah, is there any way we can change that word? Or find something else to replace it? Or, here's the other issue. Could we ask a member to come in and perhaps provide some solution to the change of this word?
So
You know where
I
I'm
want,
going.
yes, of course, and I was going to ask Jen about this as well. Okay, so I'm trying to remember what the intent of this bill is. I'm keeping that as an overarching theme. First of all, I believe you said that in statute, behavioral health is defined.
I don't know that it is defined in our statutes. The word behavioral as part of this list is in our existing definition of legally protected healthcare services. And this this.
Wait, can you finish answering?
This bill itself is the sort of update, we've been referring to it in shorthand as the updated SHIELD bill, but it's to increase protections for patients and providers around legally protected healthcare activity. When we worked on the first version of the SHIELD bill, that created the definition of legally protected healthcare activity, which I'm going to put up here in just a moment. We were trying to be as broad as possible in defining the types of services that healthcare services that may be provided in order to protect patients and providers who are seeking and receiving and providing that care. So in this existing definition of legally protected healthcare activity, for example, gender affirming healthcare services means all supplies, care, and services of a medical, behavioral health, mental health, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication relating to treatment of gender dysphoria and gender incongruence. And I believe in reproductive health care as well, it talks about services of a medical, behavioral health, mental health, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication. The reason for being as broad as possible is for a couple of reasons. One is that Vermont is one of 50 states, and not all of the states use the same terminology or have the same use of terminology, and many of them use behavioral health, as does the federal government in a lot of cases. So in looking to protect Vermont providers who are delivering services that may be considered by others in other states or at the federal level to be behavioral health, we included that term in here. In addition, it is my understanding, and you may want to hear from practitioners at some point, but that there are types of care that there's sort of a continuum that, you know, between behavioral and mental health, and that not all care fits neatly on one end or the other of that continuum. And so different providers might have a different perspective on what kind of care they provide. There are certain types of services that are about a person's well-being, but are not necessarily about a mental health condition, or maybe about regulating behavior, or about improving sleep regimens, or diet or exercise, or anger management, or for somebody who's receiving gender affirming healthcare services may literally be coaching on how somebody is representing themselves in the world. And so my concern, when I understand that there is a member who feels very strongly about the use of the term behavioral health as a substitute for mental health, and we've been very careful to try to include the term mental health and use mental health and substance use disorder services, and not to call that behavioral health. But I do think when we're looking at protecting the rights of patients and providers and their potential for liability, we should be as broad as we can be. So that is why the language is in the bill. And if the committee would like to remove it, I am happy to remove it. But the language that is in here on healthcare services says they are services for the diagnosis, prevention, treatment, cure, or relief of a physical, dental, behavioral, or mental health condition or substance use disorder, including counseling, procedures, products, devices, and medications. And this is in the context of the types of services for which advertising about healthcare services or proposed services that is untrue or clearly designed to mislead the public would fall under Vermont's Consumer Protection Act, and the Office of the Attorney General could take action against somebody who was providing misleading, untrue or misleading advertising.
Thank you, Jen. You nailed it.
Thank you.
So write that down.
I want to make sure Woody.
This is not my bill.
Yeah.
I don't know who's going to be presenting.
Oh, I thought you.
Is there,
But it's also in my bill that I'm.
It is also in your bill.
27.
Yeah, that's what I,
And I would like to have something to be able to tell the member.
Sure.
I don't think it'll appease her. I don't think she'll be pleased either way.
I have a
And
couple,
it's
I have a
just a
couple
thought.
questions and I'm gonna go in order.
Again, if we're still looking at this bill, maybe we could invite her in and just see what she had to say. Give her due. So she's not standing on the floor and
Or is it
causing
a sidebar?
situation. Yeah.
from you.
We could, no, I'm happy to hear from any member. Yeah, let's talk about arranging that. Daisy, did you have a question for Jen?
No, because I think Jen gave perhaps one of the best explanations I've heard in a long time. And I just really appreciate, as someone that's worked in that field for 20 years, I just really appreciate your recognition and such a level-headed explanation and recognition that that's not a bad word. That's a word that many of us who have worked outside Vermont have used in order to sit at a table when we're talking about integrating care and when we're talking about many other things across an entire system of health. So I appreciate your explanation of it very much.
Leslie and then Brian?
Well, I was just wondering if we could write a standard answer. If if this is gonna come up again, we now have an E2 bill, not that one, just, I can't remember. It's in some place, that we just have that language, so that we can, so you're, no.
So you can respond to her, you know,
Yeah,
just
that's
say,
what
well,
I'm
thank you, member. and-
Just
I don't
take
wanna-
what Jen said and transcribe it.
Well,
Don't give her more.
yeah,
work to
no,
do.
that's what I'm saying, so that's written down, it's in front of us.
If you want to present that, we'll go for it. The definition of it.
You want to
It's
transcribe it?
complicated.
Yeah.
I am noticing and looking, when I pulled up the legally protected healthcare activity, the definition, the description is a lot longer even than what we have in this definition in the bill. I can make it match this one. I'm not, the one in Title I, I'm not sure if that will help, but
It could also box us in. I mean, exactly what you're saying in terms of being applicable to federal things. I mean, even federally, when we talk about behavioral health, we are absolutely not talking about anybody's condition. I almost question where it was placed in this sentence because no one has a behavioral condition,
well,
right?
that's where I'm thinking maybe it makes sense to align it even more with the list here, supplies, care and services in this list.
So basically take exactly what we have in existing.
Yeah, so
And
take the
use
piece of it
that.
that isn't specific to gender affirming and reproductive healthcare services, I think.
Yeah, because behavioral health is used in terms of services, but more at a higher level, systems level, as far away from a person as possible, because I do agree with the other member. And it's not just another member, right? We're talking about a whole community of peers with lived experience that find that term incredibly offensive because a condition of mental health is never about your behavior. Never what? About your behavior.
Yeah.
Could we change in S28? Healthcare services has the same meaning as whatever VSA.
No, because that's not,
We
those
can't,
are specific to gender affirming healthcare services and reproductive healthcare services in Title I. And so it doesn't make sense this is healthcare services much more broadly, but I think it works to take, services means all supplies, care, and services of a medical, behavioral health, mental health, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication, period.
Look, I only bring it up
Yes,
because
I know.
we'll be facing it. And I don't care one way or the other. I mean, I understand it's not about how one acts or what have you that we're talking about. It's
But we need to learn something from this
Yeah.
discussion. I hear you, and I think I'm equally in agreement.
And I would say that,
And we don't want to be offensive towards the member or anyone of
Anybody,
yeah.
that community.
That's right.
and I think in many of the things that we do in here, we can make that accommodation. But I just feel as though we have to remember what we're trying to do in this bill. And also in regards to our bill around medical debt, what we're trying to do. And by excluding it in these cases, what we're doing is we're then not protecting the very thing that we're trying to protect.
Yep.
And we're opening it for interpretation. And remember, we're trying to protect ourselves from 49 other states. Vermont may not use this language, but we have to recognize that 49 other states do. And we have to be inclusive of that because we don't want them to have an out. And it's sort of the same thing with the medical debt. We're trying to help people. And we want to ensure that all healthcare services that people receive are eligible for it. We don't want to say, if we remove that, all we need is a hospital to be able to say, oh, well, this service was related to behavioral health. And all of a sudden, they're no longer eligible.
Because it's been out.
Because it's out.
Yeah.
Leslie? And I'm sorry, Brian,
I had a comment or concern.
me, look, had you asked the questions? I'm sorry, we're getting.
If I may,
Yeah. And then-
I think that you make a really important point about trying to work with our other member to help her understand why this decision was made. So I think that's important. And that will require a process, either, and I can see three processes, like the reporter of the bill talks, the chair talks, he comes to talk. I mean, they're just very ways to acknowledge this painful, situation for this individual. And I think that we should do it up front before we go on the floor. So I'm agreeing with you, is where
The
this
chair
goes.
and I have had a discussion with the member briefly.
I've had more than one.
We're not the vice chair,
Comfortable
but the,
talking about her
the
without her
ranking,
chair.
the ranking,
That's
Yeah, it
inappropriate.
feels weird to me.
ranking
The
member,
ranking?
the ranking member or vice chair.
Vice chair. Who?
You,
What am I?
yeah, what are you?
Turn around and read the sign.
Chopped liver, obviously, like.
Oh, vice chair, okay. That's the first time. You looked at me funny when I said vice.
I just feel very comfortable in that we have legislative council for a reason. They are our legislative or our legal counsel. And I feel as though we should heed the advice of our legal counsel and their expertise. And I'm willing to stand up on the floor and I will defend that. So, Brian, you
So,
have a question
well, just
or?
I find it, I'm not going to fight to remove this, but as a person in struggling with mental health and substance use issues and in recovery from a variety of things, I find the term incredibly offensive, behavioral health, like it's hurtful. Here's an example from the Centers for Medicare and Medicaid Services website, their definition of behavioral health. Behavioral health includes the emotions and behaviors that affect your overall well-being. Behavioral health is sometimes called mental health and often includes substance use. So like my point is, the problem is beyond us. The Medicare and Medicaid are offending me. They're calling mental health behavioral health. So I see the point of like, if we're interfacing with the suppressive system, we have to use the language, but it is hurtful. And like for it to be, and like another thing they had on here, on this here, it said, I thought this was useful, the AI, it found, like, I'm not gonna look at what it said, I remember, it said, mind you, this is AI crunching multiple websites and giving you an answer, it's saying like mental health is when, it's behavioral health when the diagnosis is made by an outsider on someone's behavior. And just the thought of how like disempowering that is, that if like when you're struggling from something and you're telling a provider and the provider's mindset is, I'm not listening to you, I'm observing you and passing a judgment on you. You know, and this has been a perpetual issue in the healthcare system around mental health treatment. So it's hurtful to me. It's been hurtful to other members. But I'm not going to refuse to vote yes on a bill over a term that Medicare and Medicaid uses and that we may need to use to protect people and that we may need to use to access funding, et cetera. But it is a hurtful term. Like the more I read about its use, I'm just like, this is such a gross way to think about human health, because it's really about looking at behavior and path and people who are so-called experts judging our behavior without a deep understanding of that behavior. And as a social worker, we take courses, multiple courses in what they call HBCE, human behavior and the social environment. And it's all about how every aspect of human behavior is integrated, is interconnected with our social environment. So often our behavior is a reaction to the environment we're in. And so it's kind of messed up that, you know, behavioral health providers are like, we're going to change a person's behavior. They should be also, it should also be like social environment, you know, providers or something. So I'll stop there, but I just wanted to express that, you know, as hurt as I am by this term, the more I read about it, the more upsetting it is. It is Medicaid and Medicare using it. So, I mean, yeah.
To my mind, it's not necessarily, I mean, I think there's the aspect of the federal government using the term, but I also think there are some aspects of healthcare that do not fall under either mental health or necessarily physical health that may be in the behavioral health realm.
And then,
I don't know whether I've mentioned this before or not, but behavioral health means something very different to me than mental health. And it means that there was a behavior that I was involved in. And in order for me to get well, I had to change that behavior, which I did. It had nothing to do with mental health.
I
So,
think, oh, I'm sorry.
you know,
I thought
like
you were
anger
finished.
management and things like that, nothing to do with, as far as I was concerned, with mental health. It was to do with what I was doing. And I had to correct that. So I did it. And that was a behavior that I had to deal with.
That's a good example of what I am trying to refer to. Exactly, that in using a very broad definition of what constitutes healthcare services, I think you are all wanting to be inclusive of. So I think.
I mean, it goes, it happens a lot, like with people with heart problems. There's a certain behavior that they should follow to heal.
There's still a physical problem, right? And with anger management, like it's cognitive behavioral therapy, which is the theory underpinning all psychotherapy that we use. Every behavior is connected to a thought and a feeling, and thoughts and feelings are actually connections in our brain. There's a physical circuitry. So this is why it's like concerning to strip behavior away from that, because even mental health is physical health. It's wiring in our brains, it's chemistry, it's genes being turned on and off. That being said, it's a term that's used whether we like it or not, you know?
I think that the discussion around the table has been illustrative of exactly how different people can interpret different things in different ways, which is the exact reason I feel as though this needs to be in the bill, because remember, we are trying to protect consumers, providers against other people's interpretations of healthcare services that we have as a state said are imperative or whatever the term is that we've used.
So I would suggest potentially modifying so that it tracks
Yeah,
that other definition. So that's what this would look like, and try to.
I think
Yeah,
that's
both
a
pieces.
fantastic suggestion.
Yeah.
So I'm just
The
going
only
to,
thing we want to add in here that is not in here that was in our one up here is dental.
I'm just going to ask really quickly around the room, maybe a show of hands. Is there anybody who would who really wants the word removed? And I'm going to go with the majority. So does anyone want behavioral removed from the bill?
I do, but I'm not gonna obstruct us.
Okay.
Yeah.
Okay, so we're gonna leave it in. And our legislative council will give us a great explanation of why we're doing it.
You just did. Thank you so much for
Yes,
doing the
yes.
research, Jen.
You're welcome. It's difficult because I don't want to make anybody feel bad. And that is absolutely not my intent. My concern is that the language do what,
Inclusion.
well, and that the language work.
Is
Yeah.
effective for the
Is
intent
effective
of the
for the
bill.
intent. Thank you. Any other questions on the bill? So I think that we're gonna sleep on it a little bit.
Yes,
And-
Not sleep on it.
Or not sleep on it, and we're gonna come back to it for vote tomorrow. Everybody all set? Yeah.
So sad.
All right, we can